Good morning. Today's theme is insolvent partnerships, which are rare and notoriously tricky in dealing with. So I hope to give a quick summary through some of the basic points and take a little bit of the fear out of this particular area of insolvency. There are three topics that I will be covering today. First of all, I'll be looking at what a partnership is, as it's when you've got a partnership that the Insolvent Partnerships Order applies, and when the Insolvent Partnerships Order applies, you've got a selection of procedures from the Insolvency Act that you can choose from, but they do work in slightly different ways to how you're used to dealing with them. Second thing I'm going to be talking about is how to analyse the various estates within a partnership. There are several estates involved when a partnership becomes insolvent, and it's important to identify what they all are and work out what assets and liabilities fit in each of them. And then the third thing I'm going to be talking about are the options that you have got, the range of procedures available for dealing with an insolvent partnership. So first of those topics is the question of what is a partnership. And the first thing I want to emphasize here is that a partnership is not a corporation. It has no legal personality. And that makes it different from other organizations that you are going to be used to, particularly companies, limited companies and PLCs, which you will encounter and which have got legal personality. So these slides have got slightly out of sync here. So examples of corporations that you will be dealing with are going to be things like limited companies, PLCs, which are a type of limited company, of course, registered societies, which also have a name that ends in limited, limited liability partnerships, LLPs, they of course are also corporations. And you're used to dealing with those with the normal insolvency rules that apply to companies. What are not corporations are, of course, individuals, people on their own, and various types of unincorporated organisations like clubs and societies. Many charities are unincorporated organisations, and of course, partnerships are unincorporated also. The definition of a partnership is contained in the Partnership Act 1890. And this is a very old piece of legislation, and it has not changed a great deal over time. The key definition within the Act is right at the beginning, section 1.1, which says that partnership is the relation which subsists between persons carrying on a business in common with a view of profit. There's a number of important points there. One is that partnership is about a relationship. Partnership doesn't create an entity. Partnership does not create anything with legal personality, at least not in England and Wales. I think the law in Scotland is a little bit different, but then the law in Scotland is often a little bit different. And the existence of a partnership is like a force of nature. It arises automatically when people come together to do business together to make a profit. Subsection 2 is also important, and it says there the relationship between the shareholders of a company is not itself going to be a partnership. So what the start of the Partnership Act does very, very clearly is it establishes two channels, one for companies and one for partnerships. And the business entity will be in either of those channels, but it cannot be in both of them. And a partnership, as I've already said, it's a relationship that arises automatically when people join together to run a business for profit. The bit about running the business for profit is important, and it means that other types of unincorporated organisations, clubs, societies, and charities, for example, are not partnerships. That's because they are not being run for profit. And because they are not partnerships, the Insolvent Partnerships Order does not apply to them. The Insolvent Partnerships Order does apply to partnerships, and it applies the Insolvency Act and the insolvency rules to insolvent partnerships, with some quite significant changes in how those rules and the Act work. The individual members of an unincorporated association that is in financial difficulties can themselves find that they are in financial difficulties as a result of that, because they are at risk of being personally liable for the debts of the organisation, and so they may be looking at IVAs or bankruptcy for themselves if the organisation is in serious financial difficulties. And of course that is the same for the partners in a partnership. And if the partnership fails, it may well have serious implications for the solvency of the individual partners within the partnership. Other key points from the statutory definition of partnerships is that shareholders in a company are not partners. This is setting up the two channels, partnerships and companies, that run separately and independently. Second point is that the definition refers to persons coming together in partnership. That means you can have a partnership of individuals, of people, or a partnership of companies, or a mixed partnership where some of the partners are individuals and other partners are companies. It is, of course, much less common for companies to be partners in a partnership. Normally, companies try and avoid that. Third key point is that a partnership is a relationship between the partners. It is not a legal person. It is not an entity of itself. And the fourth thing is, as I've said, a partnership is a force of nature. It comes together automatically when people join together to run a business together. We're now going to have a couple of compare and contrast slides. The first one will show the elements of a company, and the second one will show the elements of a partnership to show how companies and partnerships are different. So on this slide, you can see there's a vaguely cubic-shaped object which represents the company, and above that, but separate from it, are the shareholders, the owners of the company. And the company itself has legal personality, so it is a person in its own right, separate from the individual shareholders. As a legal person, the company itself can own property itself, so the company will be the owner of the property that it uses and owns. Its name will be at the land registry as the owner of any land that it owns. The company as a legal person is, of course, a legal fiction, so it has to deal with the outside world through agents, and its agents are its directors and its employees. They have the authority, the ability to transact, make contracts on behalf of the company, and commit to obligations with the outside world. Its directors and employees, acting as agents of the company, have no personal liability for the obligations that they are transacting. They are making those transactions as agent for the company and on behalf of the company, and to bind the company, but not to bind themselves as individuals. The next compare and contrast slide is, of course, the diagram of the partnership. And here, the partnership doesn't exist as a legal entity. It's the relationship between the four partners, A, B, C, and D. And here we've got two of the partners, C and D, who own the partnership property on behalf of the partnership. We have the partners employing employees who are agents of the partnership. The partners themselves are each individually agents of the other partners, in the same way employees are agents of all of the partners, and employees have the authority to commit all of the partners in the partnership to legal obligations, depending, of course, on the scope of the authority that employees have got. And the partners in the partnership can transact with the outside world either individually by individual partners making contracts with suppliers and customers, or by delegating that role to employees, or both, as often happens. So, having had two compare and contrast diagrams, we've now got the compare and contrast page, and I'm going to go to the bottom line in this first, which is to emphasize that perhaps the key difference between a partnership and a company is that a company has got legal personality and a partnership does not. And then the points above that are all consequences of that. So because a company has got legal personality, it is able to own its own property, but a partnership cannot. A company has got legal personality, which means it can make contracts and it can sue and be sued in the courts. A partnership is not a legal entity with legal personality, so the partnership itself cannot make contracts, cannot sue, and can be sued. And a company has legal personality which is independent from its directors and its shareholders. So shareholders can come and go, directors can come and go, the company will continue in existence, but not so with a partnership, where a partnership will end when one of the partners leaves, and a new partnership will be formed when a new partner joins. Now you're thinking, hang on, this doesn't make sense, because in your experience, you know that partnerships do own property, and you're thinking of partnerships that you have seen, you've had dealings with, that own things like land and buildings, bank accounts, office furniture and equipment. They've got books and records, vehicles, plants and tools, intellectual property rights, goodwill, a whole range of business property you will find in partnerships. But the legal analysis here is that that partnership property will be legally owned by one or more individual partners. The partnership as an entity does not exist, cannot own property. And if the partnership, using this loosely, if the partnership owns land, then the legal title to that land will be in the names of a maximum of 4 individual partners in the partnership. And the partners who own the partnership property legally will own that property as trustees. The beneficial interest in the property will belong to the partners in the partnership collectively, and the terms of the trust on which they own the property will be the terms of the partnership agreement. I haven't said anything about partnership agreements now, but there will always be at least an implied partnership agreement between the partners on the terms set in the Partnership Act, and very often partnerships will amend the position that will be set out in the Partnership Act with an express partnership agreement, but they don't need to do that. It's not a necessary requirement of a partnership. Now again, you're thinking, I told you that partnerships cannot make contracts and they can't sue and be sued. And again, you're thinking this doesn't accord with your own experience. But the point here is that legally, the contracts that are made for the partnership are made by individual partners, and each partner has joint and several authority. That means that the contracts that they make for the partnership will bind all of the other partners jointly and severally to the obligations in that contract. That means that if there is a breach of contract, the other party can sue any partner in the partnership, or they can sue all of the partners in the partnership. It's their choice. And similarly, if the breach is the other way and the partnership wishes to enforce the terms of the contract, then it will be the individual partners in the partnership who will be suing the other party to the contract. And again, you're perhaps thinking that, again, this doesn't make sense about a partnership coming to an end if a partnership leaves, or a new partnership being formed if a partnership joins. But this is very much the case. I mean, imagine a partnership of, let's call them A, B, and C, and after a period of time, a couple of years or whatever, partner A leaves. That means you've now got a partnership of B and C continuing the business. That is a new partnership. You have the partnership of A, B, and C. A leaves, the business continues, but it's now a partnership of B and C. And then, if after a period of time, a new partner joins them, let's call them D, you've now got a partnership of B, C, and D. That is a third partnership, another new partnership. Now, what may be causing the confusion is that there are tax rules that apply when a business starts up, and other tax rules that apply when a business closes down. And it would be horrifically complicated and very confusing if those rules were to apply every time there's a change in partnerships, a partner arrives or leaves. So for tax purposes, HMRC will treat the partnership as continuing with a change in the partner, but technically speaking, it's actually a new partnership that is formed when the new partner arrives, and the old partnership ends when a partner leaves. So as a result of all of this, because the partnership doesn't have legal capacity, doesn't have its own obligations, doesn't have its own property, a partnership is going to be a complicated mix of several estates, and you're going to need to unscramble them in an insolvency. So that's me having dealt with the first part of what I wanted to talk about, which is what a partnership is. We have to wait for the slides to catch up again, I'm afraid. And I now want to move on to how to analyse the various estates within a partnership, which is the next topic I'm going to be looking at. Slide pause here, the slides catch up. And when they do, I'm hoping you're going to see on screen a Venn diagram that shows three partnerships. Three partners in a partnership. And I've colour-coded those. So the first partner is the red partner, second partner is the blue partner, and the third partner is the green partner. And if you look at the centre of the diagram, you'll see the area where those three partners' interests overlap to form the joint estate of the red, blue, green partnership. And to further complicate this, each of the partners is married, so as well as having their own personal estates, their own share in the partnership estate, they've also got a separate estate their spouse owns, and there may be property that they jointly own and obligations they've got jointly with their spouse. And you can see as well that it's quite possible that, for example, the red partner and the green partner might have some other business arrangements between themselves, which is effectively another partnership of just those two. And you might have the same with the green and blue partner and the red and blue partner. So you could actually have 4 partnerships in existence between these 3 partners, as well as 3 separate joint estates, which are matrimonial estates, and the separate personal estates of each of the 3 of them, and the separate personal estates of each of the 3 spouses of them. So there's potentially quite a lot there to unscramble. And it's not just the estates that you're looking at, it's also the creditors, the debts that each of them has got. And remember that each partner, as well as being responsible for their own personal debts, they're also jointly and severally liable for all of the debts of the partnership, regardless of which of the partners may have incurred those debts on behalf of the partnership in the first place. So take the example of bankruptcy of the green partner. In that case, the creditors who will be proving in the bankruptcy debts will be firstly their own personal debts that they themselves have got, and then secondly, there will be all of the partnership creditors will have a claim as well. And you might also find that if there is a deficit in the partnership accounts, partnership is itself insolvent with its own liabilities exceeding its assets, the partnership itself will be a creditor. Each of the partners will owe money to the partnership to make up that deficit as well. And you'll remember the basic rule in bankruptcy, that the bankruptcy estate does not include any property that the bankrupt holds on behalf of anyone else. Now, because the partnership property, regardless of which of the partners owns it, is always held on trust for the partners in the partnership, that means that any partnership property that Green owns personally is going to be outside their own bankruptcy estate because they hold it on trust for themselves, for Red and Blue in the partnership. And the only estate that the trustee of Green's bankrupt estate will have in the partnership property is through the net balance on Green's current account and capital account with the partnership. And if the partnership is solvent and there's a surplus on those accounts, that's good. There is an asset there for the trustee to collect. If it's negative, if there's a deficit on those accounts with the partnership, that means that the partnership itself, the partners in the partnership, will themselves be jointly and severally a creditor in Mr. Green's, Mrs. Green's bankruptcy. So that's looking at how to analyse the estate in a partnership. Now going to move on to the final topic I want to cover, which is the options for an insolvent partnership. And there are sort of 5 options here. I've listed them in this way in terms of familiarity, but I have cheated on a couple of them. But the 5 options that I've listed here, we'll talk about. Option 1 is bankruptcy. Option 2, voluntary arrangements. Option 3 is administration. Option 4, which is not really an option, is CVL. And option 5, which again is absolutely not an option, is an NVL. But I will talk about how to deal with an insolvent partnership where a voluntary liquidation would be the right thing to do if it were a company. So first of all, let's look at option 1, bankruptcy. Bankruptcy is actually surprisingly complicated and there are many bankruptcy options. And the reason why there are so many bankruptcy options is because of this that I was just talking about with the different estates. The options exist as a way of trying to deal with the different estates that you've got, and particularly the joint estate of the partnership property, which is actually outside the bankruptcy. Let's go back to the slide that I want to be on. What you can't see on the slides, what I am going to talk about is there are several bankruptcy options. And this is because the partnership assets are not in the individual partners' estates. So what you may need to deal with the partnership assets is a court order to allow for the partnership estate to be wound up in bankruptcy. that is then applying the bankruptcy rules to the partnership as well. So in a case like that, you might have bankruptcy orders against red, green, and blue as individuals, and then you would get a court order that would either allow you to administer the red, blue, green partnership estate in bankruptcy, or that would actually effectively make a bankruptcy order against that joint estate. The other options that you've got, other than winding up the joint estate in bankruptcy, would be to wind up the partnership as an unregistered company. And for that, you would need to get a winding up order against it, so it is wound up effectively as a compulsory liquidation. If the partners are well organised, understand their obligations, and are looking at this from the aspect of what is in the best interest of creditors and the insolvency practitioner dealing with this, series of very big ifs there, then they would be able to petition jointly for their own bankruptcy and at the same time for their partnership estate to be wound up in bankruptcy as well. The other option that you've got would be to authorise the partners themselves to realise the partnership assets, which they are holding on trust for the partnership, of course, authorise them to realise those assets under your supervision and direction. That's perhaps the right way to go if the value of those assets is relatively modest, or if they're straightforward, uncomplicated in how you realise them. But you could quickly find yourselves running into difficulties there in terms of how you would deal with those realisations, how you would administer them, and you might find that you then have to get a court order to allow you to wind up, to distribute those assets, to deal with those assets through the bankruptcy process. Second option that you've got beyond bankruptcy is a voluntary arrangement. And of course, this could be an individual voluntary arrangement or a partnership voluntary arrangement, which is essentially a CVA with modification, so it works for the partnership rather than for a company, or both IVAs and CVAs. Now, if you're looking at the IVAs of individual partners, those IVAs should not normally deal with partnership property, and their interest in the partnership will be either to collect the surplus owing on the current and capital accounts in the partnership, in which case the individual debtor will be a creditor of the partnership, or they may be a debtor of the partnership if there's a deficit balance on those accounts. You can very often deal with partnerships with a limited number of partners through interlocking IVAs, and you can deal with the partnership property with the consent of each of those debtors through those interlocking IVAs, but you do have to tread very carefully and look out for conflicts of interest there, because you may find that different partners have different ideas about what contributions should be called from which estate. And you may find a PVA is the best way of dealing with the partnership assets and liabilities itself, but that, of course, should not be dealing with the personal estates and the personal creditors of each of the partners. And you may find that the partners themselves will need IVAs or bankruptcy or a combination of those. And again, you have to watch out for conflicts of interest there in terms of what is best for each individual partner and who is going to be representing each individual partner in their relationship with the PVA. Third option is administration, and administration is very much a first aid procedure here. When going into an administration, the main reason for having an administration of a partnership is to ring fence the assets, to set up this defensive wall, this moratorium protection around the assets in the partnership, and to ensure the orderly protection of them and realisation of them for the creditors. But you do need an exit in mind for an administration, and that may be a PVA, it may be interlocking IVAs, but you'll need a fairly clear idea of what it is that you're going to be asking the creditors to agree to. And it's not always clear how well the administration will itself protect the partners' individual estates from business creditors, because of course they've got the right not only to make a claim against the partnership assets, but they've also got a right to bring claims against each of the partners individually. And so you might need to look at interim orders for each of the individual partners as well to protect them against business creditors. And it's not always clear either which creditor is going to be a business creditor and which one is going to be a personal creditor. And you may find that some obligations to HMRC, for example, there may be a difference of opinion between you and HMRC as to whether they are actually bound by the administration or not. Fourth option I've got is a CVL, and a CVL is of course not an option. There is no CVL procedure for partnerships, but in situations where you would be looking at a CVL for the business, if it were a company, you might find that a PVA would be the right thing to do, because it will give you a way of having an orderly closure of the business, winding up of its affairs, and then distribution of assets to the creditors of the business. So PVA may well be the right thing to look at when you might otherwise be looking at a CVL. So in that sense, a PVA is perhaps wider in scope in terms of its possibilities than a CVA would be, because a CVA is something you would normally be looking at if the business was going to continue. A PVA can be very, very appropriate when the business is going to cease trading or has ceased trading. And it might be that where you've got the transfer of the business from one partnership to another partnership, so for example, you might have a partnership of 4 that is insolvent, but 2 of the partners are going to be continuing the business, and they'll be doing so through a new partnership. So the old partnership of the 4 partners could then be wound up through a PVA as a way of ring fencing obligations from the continuing partners. Fifth option, which is not an option, is an MVL. And again, there are no voluntary liquidation procedures for partnerships, so an MVL is not actually an option. But it is possible to dissolve a solvent partnership either by agreement or with a court order, according to what may be most appropriate in the circumstances. And what's appropriate will depend upon the degree of dissent between the partners in the partnership. So that's me now having covered the options. That's the end of the presentation itself. If you've got any questions, then please do ask them now. I'll just have a squint at the dashboard to see if there's anything that I can see up there that looks like a question. Now, that may be a question there. Let me have a look. Just bear with me. So, question here from Mark is suggesting a 2-person partnership and one person falls ill and is unable to continue in business, make a profit. The question is, can that still be regarded as a partnership? And if not, how to deal with that in an insolvent situation? I think the answer to that is the lawyer's favourite answer. It depends. Whether one person being incapacitated in a partnership is itself going to dissolve the partnership will depend upon what the partners have agreed within the partnership agreement, and it will depend upon the degree of incapacity as well. But let's assume that the partnership is dissolved as a result of that. Then yes, you'll be effectively ruling off the partnership as at the date when the ill partner leaves the partnership. And you would then have to deal with that as an insolvent partnership. Whether the other partner, the healthy partner, could continue the business or not would again depend upon the agreement between the two partners. Probably in most cases it would make sense for them to continue the business because that would trigger fewer obligations than shutting the business down, all else being equal. But then they would have to pay fair value for what they were buying for the partnership. So you would, if you were representing the partnership there, it may be that the right way of dealing with that would be to have, let's say, a PVA for the partnership of two, and then for you as supervisor of the PVA to be looking at realising the debtors of the partnership through the partner who's continuing on their own, realising the other assets through collecting a purchase price from the partner who is continuing with the business, and then you'll be distributing that through the PVA. Where that leaves the individual partners is going to then depend upon how insolvent the partnership is with the PVA, and what arrangements each of the two partners can then make for dealing with any shortfall that they've got to creditors, whether they can do that informally or whether either of them would need any formal procedure. So, Mark, thank you very much. That's a good question, and it's a nice illustration, I think, of the sort of situation that can arise and how to deal with it. I hope that's been a useful answer. Happy to take any more questions, but if not, here are some dates for your diary. First of all, haven't got it yet on this list. The 10th of February is going to be the date of the next coffee break briefing. Secondly, the first two dates on there are both wrong. The next regional meeting of R3 will actually be on the 20th of February, which is a Thursday, and that's going to be at the Empress of Blandings, just outside Southampton. The technical breakfast briefing that R3 will be running will be in April. I don't have the date for that just yet. I'm intending to go to the Personal Insolvency Forum in Manchester at the end of February, and I'll also be at the R3 Southern Thames Valley Forum in Bournemouth from the 20th of March. We've got the dates there for the SESCA seminars and conference. We've got the date for the R3 SPG forum, which I'm also hoping to attend. We haven't yet got a date confirmed for the Fretton's 4th Insolvency Conference, which will be at a venue in or around the New Forest, and we're looking at probably around the 13th of June, but I hope to be able to confirm that to you before too long. And with that, thank you very much for your attendance today. I hope you found this useful, and see you again on the 10th of February, if not before. Thank you all very much, and goodbye.